we shall discuss in this lecture, we shall discuss natural justice. We shall discuss natural justice, the principles or the doctrine of natural justice. Now, when we say natural justice in law, natural justice in law can be used in two main senses. The first sense is what we refer to as the broader sense, and then the second sense is what we can call the narrower sense. In the broader or the wider sense, or let's say the less technical sense, natural justice refers to what is fair or what is reasonable or what is inherently equitable, in the sense that everybody can relate to same. So anything that is fair, reasonable, or inherently equitable is what we can refer to as natural justice in the broad sense. And then we have the use of the expression natural justice in the narrow sense. The narrow or the technical sense refers to two key principles. When we use natural justice in the technical legal sense, it can refer to two principles. One is what we call the principle of nemo judex in causa sua. Nemo judex in causa sua. And then the other leg is the principle of Audi Alteram Partem. Nemo judex in causa sua essentially means that no man shall be a judge in his own cause, or that we refer to the nemo judex in causa sua as the rule against bias or the rule against partiality, or the rule that a decision maker must not be biased. So when we look at natural justice in the technical sense, we are saying that in the technical sense, it can either refer to nemo judex in causa sua or Audi Alteram Partem. Nemo judex in causa sua we have explained as the rule that a man should not be a judge in his own cause, or the nemo judex in causa sua means that there is a rule against partiality, or it can also mean the rule that a decision maker must not be biased. That is what we mean by nemo judex in causa sua. And then there's another leg of natural justice. The other leg of natural justice is what we call Audi Alteram Partem. Audi Alteram Partem means that all other sides must be heard before judgment is passed against them. So Audi Alteram Partem essentially means that the right to a fair hearing. The right to a fair hearing. Now, the main reason why, when we refer to natural, we have this principle of natural justice, is because we want people who approach the seat of justice. We want them to approach the seat of justice and leave knowing that justice has been done. We don't want people to leave the seat of justice and then to think that a particular judge has been biased. And so it is of crucial importance that justice is not only to be seen to have been done, but justice is supposed to have been manifestly and undoubtedly be seen to have been done. That is the essence of natural justice. So that if we say that it is the rule against bias, if we say that all parties must be given a right to be heard, it means that if you are a decision maker, even if you saw somebody engaging in an unlawful activity and you have seen it yourself, before you condemn the person that you have seen committing the activity, regardless of the evidence you have on record, you must make sure you give the person a right to be heard before you go ahead and pass judgments. So it is not really about whether whatever you are doing is substantively right or not. This one deals more with the procedure. That the procedure you use before arriving at your decision is what the law is saying, that it must be a procedure which must be tainted with fairness. And so, in that same vein, if you are a judge and then you have even seen somebody committing an offense, and you know that you saw the person stealing, when the matter comes before you as a judge, by virtue of the fact that you have a preconceived idea, you already have a foreknowledge of the facts, then it means that it is possible that you may not exercise some bit of fairness. You may be biased in the way you arrive at your conclusion. And therefore, even though you may have seen the person committing the offense of stealing, when the person is brought to your court, in order for the person to be given a fair opportunity for him to think that and know that justice has been manifestly done, you, the judge who has foreknowledge of the facts, you must recuse yourself and you must not participate in the adjudication of the matter. And so, in the case of R versus Sussex justices, ex parte McCarthy, R versus Sussex justices, Sussex is spelled SUSSEX, justices, ex parte McCarthy, 1924, 1 King's Bench at page 256 at page 269. This is what Lord Hewart CJ said about the natural justice. He said that, and I quote, "It is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should be manifestly and undoubtedly be seen to have been done." Again, it is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to have been done. And the quote ends. And then also in the case of Metropolitan Properties Company Limited versus Lannon. Lannon is spelled Lannon. This is reported in 1968, three weekly law reports, page 694. In this case, Lord Denning observed as follows, and I quote. Lord Denning says as follows, and I quote, "Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking the judge was biased. Quote ends. So if you look at these two cases, we are all trying to show that it's not really about substantively whether you have done the right thing or wrong. We want to be sure that when people leave the seat of justice, they are going to be sure that justice has not only been done, but justice has been undoubtedly and manifestly be seen to have been done. So natural justice is not really concerned about the merits of the case, whether you were right in coming to your conclusion or not. So it may be that the substance of your judgment shows that you are right, but natural justice is not concerned about the rightness or wrongness of your decision. What it is concerned about is the procedure you use to arrive at your decision. If you were somebody who gave a decision without giving the other party a right to be heard, then you have violated natural justice and your decision is liable to be quashed as being null and void. If you were somebody who adjudicated upon a matter that you have an interest in, then you have flouted the rule against bias. And in that case, the decision must be rendered null and void. So this is an insight about the two components of natural justice: nemo dudex in causa sua and Audi Alteram Partem. So we shall begin by first of all discussing Audi Alteram Partem, which is the right to be heard, or that the right to a fair hearing, or that an adjudicator must hear both sides before adjudicating upon the matter. The rule of Audi Alteram Partem. Now, for those of us who are familiar with discussions and stories in the Bible, if you examine the story of Adam and Eve in the Garden of Eden, it has been argued that this principle of Audi Alteram Partem can be traced all the way to the Garden of Eden, when Adam and Eve violated God's commandments. It will be recalled that when Adam and Eve went to eat the forbidden fruits, the Bible indicates that God is all-knowing, meaning that since God is all-knowing, he definitely would know that Adam and Eve had eaten the forbidden fruits. But when the Lord came, he didn't just wake up and tell Adam and Eve that I have seen that you have eaten the forbidden fruit, so pack your things and leave the Garden of Eden. The Bible says that the Lord asked them, what have you done? And it was after they had answered and confessed about what they had done before the Lord passed judgment upon them. What it means is that even the Lord who is all-knowing, the Lord who is omniscient, the Lord who is omnipotent, he first of all gave Adam and Eve the right to be heard before he went ahead to pass judgment. And so it has been argued that this principle of Audi Alteram Partem, it dates as far back to the Garden of Eden, where the good Lord had to hear Adam and Eve before he passed judgment. And therefore, as far back as in the year of 1915, in the English case of Local Government Board versus ARLIDGE, ARLIDGE is spelled ARLIDGE, reported in 1915 AC at page 120, specifically at page 138. This is what Viscount Haldane said, and I quote. It says that those who duty it is to decide must act judicially. They must deal with the question referred to them without bias, and they must give to each of the parties the opportunity of adequately presenting the case made. The decision must come to the spirit and with a sense of responsibility of a tribunal whose duty it is to mete out justice. In the quote ends. You will notice that Viscount Haldane in the Local Government Board versus ARLIDGE indicated that those whose duty it is to act must act judicially, and then they must afford each of the parties the opportunity of adequately presenting the case made. Meaning that they are recognizing that parties must be given a right to be heard. So the Audi Alteram Partem rule essentially means that a person should not be judged until he has been given a fair hearing. And also we'll soon see when you read the cases, remember I mentioned that people have traced this concept all the way to the Garden of Eden, when the good Lord had to hear out Adam and Eve before passing out judgment. You will notice that, as we will soon see from the cases, that the principle has even been traced all the way to even our customary law and our traditional society. When you realize that before an animal is killed or a fowl is killed, the fowl will be given water to drink before the fowl is slaughtered. It has been held that that practice is an indication of giving the fowl a right to be heard before judgment is passed against the fowl. That is how fundamental that concept of Audi Alteram Partem is. The right to be heard, traced all the way to the Garden of Eden, traced all the way to our customary communities. And we can see that as far back as in the year 1915, in the English case of Local Government Boards versus ARLIDGE. Now, we've heard of the right to be heard several times. But what is the content of this right to be heard? Now, it is important that I mention that when we say a party must be given a right to be heard, it doesn't mean that the decision maker must operate like a court of law, where the decision maker is going to use rules of evidence and things like that go mechanical according to what lawyers learn in. No. When we talk about the content of Audi Alteram Partem, or the content or the requirement of the right to be heard, there are some basic and fundamental components that must be present. It means that there must be a right to representation. Now, right to representation essentially means that the person who is affected by the judgment or decision that is about to be made, that person should be informed of the place, he should be informed of the date, he should be informed of the time of the hearing for him to adequately prepare for his case. What this means is that if there is a hearing on a person's case and the person is given notice this morning that come and appear at 10 a.m., when you are very well aware that the person is traveling to Tamale for medical attention that morning, if the person fails to show up at the meeting and you go ahead and you pass a decision against that person, even though you gave the person an opportunity to come this morning, the person was not given adequate notice. He wasn't given adequate time to prepare for his case. And therefore, the hearing can be quashed as being in breach of the right of the person's right to a fair hearing. So when we say Audi Alteram Partem, it means that the party must be given adequate information and notice about the place, about the dates, about the time of the hearing. Again, the person who is to be affected by the decision, he should be given adequate notice to prepare for his or her case. Again, that person must also be given access to documents that he or she is relying on to make their case. So if it's a company and there are some board minutes that the person is supposed to be entitled to make out the person's case, you, the company that has summoned the person to appear before the disciplinary board, you cannot decide to withhold crucial documents that you know that are important to enable the person prove his case. You cannot withhold those documents. There are documents that you must grant the person access to so that he will use those documents to prove his case. Again, when you pass a decision against the person on some particular charges, the right to be heard means that the person is supposed to know the reasons for the order that you have given. So if I've appeared before you, you have heard some charges against me, and you are even given a ruling, at least I must know the basis of the ruling that you are given. These are all components of the right to be heard. If a person is being charged for a particular offense, if the person is being charged for particular conduct, it is important for the person to know what the charge is, particulars of the charge, so that the person can respond appropriately. Also, the right to be heard means that the person affected must be afforded the right to legal representation, meaning that if the person has been charged for a particular conduct and he wants to be represented by a lawyer, he should be given the opportunity to be represented by a lawyer. Now, remember, I have mentioned that when we say that you must be given a right to be heard, it doesn't mean that you should be given right to be heard in a formal way like a court of law. What this means is that if you are being told that you have been charged for a particular conduct and that they have found you to have committed this offense, and therefore provide your explanation in writing as to why disciplinary action should not be taken against you. When you provide your response in writing, they may not invite you to a room to ask you questions, but your response in writing can be the basis for disciplinary action to be taken against you. And when such disciplinary action has been taken, you will not be heard to say that you were not given the right to be heard orally. Right to be heard doesn't necessarily mean that you must be heard orally for you to do cross-examination and things. It may be that they may give you a right to be heard in writing. That may be enough for compliance with the right to be heard, Audi Alteram Partem. Now, having explained Audi Alteram Partem and the components of Audi Alteram Partem, it is important to note that when a person has been given a right to be heard, when you have been given notice of the date of the hearing and you refuse to attend the hearing, when the case proceeds and then orders are made against you, you cannot be here to say that you were not given the opportunity to be heard. This is because once you have been given a right to be heard, then that is enough. If you refuse to attend the hearing and orders are made against you, those orders are still binding against you. And then the next question is, who are the bodies? What categories of bodies should be the ones that would be applying this principle of Audi Alteram Partem, or the right to be heard? The general rule is that every tribunal having authority to adjudicate upon matters involving civil consequences should be able to comply with this Audi Alteram Partem principle. Every tribunal having authority should adjudicate upon matters involving civil consequences, they should comply with this Audi Alteram Partem rule. And it must be mentioned that even though natural justice is an expression of English common law, it appears that the Constitution of Ghana has recognized the applicability of this natural justice principle of Audi Alteram Partem in some provisions of the Constitution, especially Article 23 of the Constitution. Article 23 of the Constitution says that, and I quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law. And persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. You will notice that Article 23 makes it clear that administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law. And so if it says that you must act fairly and reasonably and in accordance with the obligations imposed upon you by law, acting fairly and reasonably cannot give you the right to punish a person without giving the person a right to be heard. So acting fairly and reasonably would definitely mean that you must give the party a right to be heard before passing judgment. Also important is Article 296 of the Constitution. Article 296 of the Constitution reads as follows: that where in this Constitution or in any other law, discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, whether by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. It means that once you have been given discretion to exercise any power, you shall imply a duty to be fair and candid, and it shall also not be arbitrary. If we say it must not be arbitrary, what do we mean? It means that you must make sure that you have heard all parties before you can adjudicate upon the matter. That is Article 296 of the Constitution. So we have seen reflections of this natural justice principle under Article 23 of the Constitution, which enjoins administrative bodies and officials to act fairly and reasonably. We've also seen Article 296 of the Constitution. That says that if the Constitution gives you the obligation to exercise a discretion, it shall imply a duty to be fair and candid, and that the decision you give should not be arbitrary and should not be born out of personal dislike. And also look at Article 19 Clause 13, also of the 1992 Constitution of Ghana. Article 19 Clause 13, also of the 1992 Constitution of Ghana. And this is what it says, and I quote: an adjudicating authority for the determination of the existence or extent of a civil right or obligation shall, subject to the provisions of this Constitution, be established by law and shall be independent and impartial. And where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. The case shall be given a fair hearing within a reasonable time. That is Article 19, Clause 13 of the 1992 Constitution. That an adjudicating authority that has the power for the determination of the existence of a civil right obligation, you must make sure that you give all parties a fair hearing within a reasonable time. And so even though I have mentioned that natural justice is an offshoot of the common law, we have seen reflections of this Audi Alteram Partem rule under Article 23 of the Constitution, under Article 296 of the Constitution, and also under Article 19, Clause 13 of the 1992 Constitution. Having given the broad framework about the components of Audi Alteram Partem, having given the broad framework about the basis for applying this Audi Alteram Partem rule in Ghana, indicating that it is embedded in our rules as being an offshoot of the common law. So even because under Article 11 of our Constitution, the common law is part of the laws of Ghana. So insofar as natural justice is a component of the common law, it has already been imbibed as part of our laws by virtue of Article 11 of the Constitution. But not only that, we have gone a step further to enact Clause 13 of Article 19, Article 23, and Article 296 to give stronger fortification to the doctrine of Audi Alteram Partem in the Republic of Ghana. Next thing is to find out what are the bodies that it has been held as this principle of Audi Alteram Partem should apply to. What are the bodies that should follow this principle of Audi Alteram Partem? What I'll do at this point is that I will go through the cases that have been applied so far in Ghana, and while I go through each of them, I'll be indicating the people that the principle has been applied to. So the first category of bodies is that the principle of Audi Alteram Partem has been held to apply to public bodies. It has been held to apply to persons making judicial or quasi-judicial decisions and executive or administrative decisions. Persons exercising judicial or quasi-judicial decisions. And over there, I refer you to the case of Ridge versus Baldwin. Ridge versus Baldwin. Ridge is spelled R-I-D-G-E versus Baldwin, B-A-L-D-W-I-N. Reported in 1964, AC at page 40. In this case, a police constable was dismissed from his post by a watch committee purporting to be acting under the powers of police discipline regulations. Now, what is important to note about Ridge and Baldwin is that the appellant in this case was not even informed of the charges that were preferred or the charges that were alleged against him. The appellant in this case was also not given any opportunity to be heard in his defense. The House of Lords reversed the appellant's dismissal and quashed it on the ground that the decision sinned against the rules of natural justice, specifically Audi Alteram Partem, the right to be heard. So Ridge and Baldwin shows that the rule has been applied to public bodies or persons exercising any form of judicial or quasi-judicial or executive or administrative decisions. The next categories of people or bodies that have been held to be bound to observe this principle of natural justice is that in Ghana, the principle of Audi Alteram Partem has been applied to commissions of inquiry. And on this, I refer you to the case of Republic versus State Fishing Corporation, Commission of Enquiry, ex parte Bannerman, reported in 1967, Ghana Law Reports at page 536, ex parte Bannerman. The applicant in this case, Bannerman, was at the time before this action was commenced, he was the distribution marketing manager of Fishing Corporation. Now, a inquiry was set up to inquire into the management of this state fishing company. During its sittings, some allegations of larceny were made against Bannerman. Based on these allegations, a letter was written to the applicants by the chairman of the Commission of Enquiry. And then the essence of the letter was that they were relieving him of his duties and responsibilities as the distribution marketing manager of the corporation. Meanwhile, he had not been offered any opportunity to be heard on those allegations of larceny that had been made against him at the Commission of Enquiry. The decision of the court in this case was delivered by Eduse J. And he quashed the decision of the Commission of Enquiry on the ground that it was an affront and breach of the applicant's right to be heard. And therefore, the decision was quashed and the applicant had to be reinstated. This is the holding of the court as captured in holding 2 of the head notes. And I quote, that even if the commission or its chairman had the power to suspend the applicants, in the circumstances, its exercise would have been deemed capricious. Whether the chairman was acting administratively or judicially in suspending the applicants, he was still subject to the rules of natural justice, and in particular to the Audi Alteram Partem rules. This rule was not confined to the conduct of strictly legal tribunals, but was applicable to every tribunal or body of persons invested with authority to adjudicate upon matters involving civil consequences to individuals. So you can realize that Eduse D in the Republic versus State Fishing Corporation Commission of Enquiry, ex parte Bannerman, which is reported in the 1967 Ghana Law Reports, Eduse J is saying that even if the Commission of Enquiry or its chairman had the power to suspend the applicant, in the circumstance, the manner in which they carried out the suspension will be deemed capricious. This is because, as was noted, whether they were acting administratively or judicially in suspending the applicant, he was still subject to the rules of natural justice, and they were bound to obey the rule of Audi Alteram Partem. And which means that that rule was not confined to the conduct of strictly legal tribunals, but was applicable to every tribunal or body of persons invested with authority to adjudicate upon matters involving civil consequences to individuals. So the suspension was quashed because the applicant was not given a right to be heard. This is the crux of the case of ex parte Bannerman. Eduse J delivered himself at page 536 of the reports. We are still on the case of ex parte Bannerman, and this is what Eduse J said, and I quote. This principle of natural justice is usually referred to as the Audi Alteram Partem rule. And even God himself did not pass sentence upon Adam before he was called upon to make his defense. Adam, says God, where art thou Hast thou not eaten of the tree whereof I commanded thee that thou should not eat? Edusei went ahead to say as follows, and I quote, the applicant herein by his suspension will be deprived of at least of his emoluments, which deprivation is in the nature of a penalty, and for such punishment to be meted out against him without a hearing of a side of the story militates against even good conscience. Such a suspension is against justice and rights. The consequence, in my view, is that there was abnegation of the judicial duties involved in the function of the Commission of Enquiry or its chairman, with a result that their decision must be regarded as of no effect and invalid. So you can see in this case of Republic versus State Fishing Corporation, ex parte Bannerman, that the court has applied this principle of Audi Alteram Partem to commissions of inquiry, that they are bound to also obey this Audi Alteram Partem rule. Again, this principle of Audi Alteram Partem has been applied in the case of the Republic versus Asokore Traditional Council, ex parte Tiwa. Republic versus Asokore Traditional Council. Asokore is spelled Asokore, Traditional Council. Ex parte Tiwa. Report Tiwa is spelled Tiwaa. Reported in 1976. 2 Ghana Law Reports at page 231. In this case, the court noted that the application of this Audi Alteram Partem rule was also applicable to chieftaincy tribunals, traditional councils, and National House of Chiefs. Because in this case, the Queen Mother had been distilled in absentia by the Asokore Traditional Council, and the Queen Mother had not even been given any opportunity to defend herself or even to know the reason or crime behind her distillment. The Traditional Council had formulated no charges against her, and then they have just gone ahead to distill her in absentia. It was held that what the Traditional Council did was in breach of the rule of natural justice, and therefore same was accordingly declared as null and void. So we have seen that the rule can apply to public disciplinary bodies, like we have seen in Rage and Baldwin. We have seen that the Audi Alteram Partem rule can apply to commissions of inquiry, like we saw in ex parte Bannerman. Now we have seen that it also applies to chieftaincy tribunals, like we have seen in ex parte Tiwa. What you can see is that we see a manifestation of the words of Edusei in ex parte Bannerman, that the rule of natural justice, specifically Audi Alteram Partem, applies to everybody that is exercising any form of administrative or judicial authority that had involving civil consequences on individuals, then it's applicable to you. That is why we've seen how it applies to public disciplinary bodies, like we saw in Ridge and Baldwin. We've seen that in ex parte Bannerman, and we've seen that in ex parte Tiwa. Another case which explains the applicability of this Audi Alteram Partem rule in Ghana is the case of Abuaje versus Ghana Commercial Bank, reported in 2001-2002, Supreme Court of Ghana Law Reports at page 797. Now, these were the essential facts of Abuaje versus Ghana Commercial Bank. Abuaje versus Ghana Commercial Bank. The plaintiff in this case, he was a senior manager of the defendant bank. Now, following some routine checks that was conducted by the inspection or audit division of the bank, the plaintiff over here was given 2 queries relating to two separate sums of money paid into the bank accounts of two customers of the bank. Now, after the plaintiff was served with these two queries, the plaintiff, in response, admitted that he had authorized the payments and that he did the authorization in the course of his statutory duties. Now, in the bank's considered opinion, the bank considered the said authorization to be fraudulent and accordingly took a decision to suspend the plaintiff. Now, what is important to note from the facts is that in the course of the proceedings leading to the suspension of the plaintiff was neither served with any notice nor the charges of the proceedings. However, the committee went ahead to recommend to the executive committee of the bank that the plaintiff be warned for negligence of duty and that his salary be reduced by 1 notch. Now, this was the recommendation made by the committee to the executive committee of the bank. The plaintiff was warned for negligence of duty and his salary be reduced by 1 notch. And then upon further consideration, the executive committee, in this case, they went ahead to increase the punishment of the plaintiff once again without giving him a hearing. Instead of the 1 notch of salary reduction that was recommended by the committee, the executive committee went ahead to recommend 4 notches to the board of the bank. Now, the board also ignored all these recommendations and went ahead to dismiss the plaintiff on grounds of misconduct. And it is important to note that from the disciplinary committee stage to the executive committee stage to the decision taken by the board to dismiss the applicant for gross misconduct, in all of these, the applicant, the plaintiff in this case, was not given a right, he wasn't given any notice or hearing at all. And therefore, the action was brought by the plaintiff, which went all the way to the Supreme Court on the ground that the dismissal was in breach of his right to be heard. Supreme Court went ahead to quash the dismissal on the basis that it was an affront to the plaintiff's right to be heard. This is what Justice Joyce Bamford Addo GSC said, and I quote. I'm quoting the dictum of Joyce Bamford Addo GSC, and I'm quoting. In this case, the administrative body trying the plaintiff, who suffered the highest and toughest sanction of dismissal, should in the course of fair trial have been served with proper disciplinary charges and given adequate notice of the date of hearing, as well as be given the opportunity to be heard. The mere fact that the rules of the bank did not mention this does not relieve the defendant of the duty to comply with the rules of natural justice and fair trial. Just as in a civil proceeding, proper service of notice on the defendant is a condition precedent to a fair trial, so also in this case, a proper notice to plaintiff is a sine qua non to a fair hearing of the case against him. If this is neglected to be done, a final decision will be declared a nullity, and the quote ends. So you can see that the court went ahead to declare the dismissal a nullity because in all of those procedural steps that were for the effect of imposing sanctions on the plaintiff was not given any right to be heard. So the court went ahead to note that in this case, the query they served the plaintiff with, the query was not the same as a disciplinary charge or notice of ongoing disciplinary proceedings. So the query they initially served him with, that he responded to, was not enough. The court noted that they had to rather go ahead and give him charges, let him appear before a disciplinary body and answer the charges. And therefore, since they didn't do that, whatever they passed was null and void. The next case that applies this rule of Audi Alteram Partem in Ghana is the case of Awuni versus West African Examination Council. Awuni is spelled AWUNI versus West African Examination Council, reported in 2003-2004, Supreme Court of Ghana Law reports at page 471. Now, the facts of this case are briefly that WAEC had taken a decision to cancel the results of the appellant and 12 other students and candidates who sat for the examination. The WAEC had taken the decision to cancel the results of the appellant and 12 other persons after a preliminary investigation established that these candidates were involved in examination malpractices. Now, it was the contention of the defendant that they had to impose these sanctions in order to protect the sanctity of the institution. And that, according to them, it was very, very clear that the students had engaged in examination malpractice, and that the issues were so clear that they need not even invite the appellants for a hearing. And they went ahead to cancel their results. Once again, the Supreme Court quashed the cancellation of the results because the Supreme Court held that they ought to have given the appellants a right to be heard before they went ahead to cancel the results. The Supreme Court in this majority decision, and one of the judges who wrote for the majority is the GSC. And after he had quoted Article 23 of the 1992 Constitution, you remember Article 23, it was imposes upon administrative bodies and tribunals the duty to act fairly and reasonably and in accordance with law. So Pega GSC, after referring to Article 23 of the Constitution, said as follows, and I quote, and this is in the case of Awuni versus WAEC. Pega GSC said as follows: the phrase "to act fairly and reasonably," in my opinion, necessarily imports a duty to observe the common law maxim of Audi Alteram Partem and other principles of natural justice, which is very much part of our jurisprudence and are implicit in the constitutional provisions in Article 23. Because I cannot contemplate how a person could be said to have acted fairly and reasonably if he did not give either notice or hearing to another who was entitled to such notice or hearing before taking a decision which adversely affects his rights. Neither can I contemplate a situation where a person could be said to have acted fairly and reasonably if he acted as a judge in his own cause or he gave a biased and perverse decision. You see that the GSC, in giving their justification why the decision of White had to be quashed, indicated that the decision they took to cancel the results without giving the appellant a right to be heard was in breach of their rights under Article 23, which is supposed to give them a right to a fair hearing. So for Akufu GSC also, after quoting Article 23, still in Awuni versus WAEC, said as follows, after she has quoted Article 23. She said as follows, and I quote: thus, by this article, and by this article, she's referring to Article 23, the right to administrative justice is given constitutional force, the objective being the assurance to all persons the due observance and application of the principles of natural justice, which foster due process and the stated qualities in the performance of administrative activities that affect them. In my view, the scope of Article 23 is such that there is no distinction made between acts done in the exercise of ordinary administrative functions and quasi-judicial administrative functions. Where a body or officer has an administrative function to perform, the activity must be conducted with and reflect the qualities of fairness, reasonableness, and legal compliance. So these were the reasons the Supreme Court gave in quashing the cancellation of results that was done by WAEC. So what we have done so far in this lecture is to explain that natural justice refers to two key components or two key concepts of Audi Alteram Partem and nemo judex in causa sua. In this lecture, we have gone ahead to throw more light on the Audi Alteram Partem rule. We have looked at the people that the Audi Alteram Partem rule applies to. We have seen the components and contents of what the Audi Alteram Partem rule says. We have looked at the bodies that the Audi Alteram Partem rule applies to, and we've seen how it has been applied in the case law in Ghana. And what we have always mentioned is that once a body violates this Audi Alteram Partem rule, their decision is liable to be quashed as being null and void. Specifically at page 337, where Lord Denning said as follows, and I quote, that if the right to be heard is to be a real right, which is worth anything, it must carry with it a right in the accused man to know that case which is made against him. He must know what evidence has been given and what statements have been made affecting him. Then he must be given a fair opportunity to correct or contradict them. And so, as we've seen, natural justice or the Alteram Partem means that the person must not only be given the right to be heard, he must give him the opportunity to know the case and the nature of the evidence being brought against him so that he can answer or contradict them. This is the end of our lecture on Audi Alteram Partem rule and how it's been applied in Ghana. Thank you.